morning. Please be seated. This is the time set for oral argument in SWVP GTIS MR LLC versus PINAL County. Our tax number 16-0017. Each side will have 20 minutes within which to present their arguments here this morning. The appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of the clock in that regard. We have read the briefs, we've been through the record, and we've conferenced the case. So we're familiar with the issues that you've raised in the background. So please keep that in mind when you make your arguments here today. We're recording these proceedings both by audio and video, and the video will be available on YouTube in a matter of days if you're interested in seeing that. As you approach the podium, however, please identify yourself and your client for us. With that, appellant may proceed.
Thank you very much. May it please the court. I'm Kelly Gorey with Rose Law Group for Plaintiff Southwest Value Partners. And I want to thank the court for its order last week. We appreciate the time and dedication that has already been invested in this case. I don't believe there's a need for me to go in depth over the facts. I believe the court is very well aware of those. So that being said, I'm going to go ahead and jump right into the issues from last week's order. The first issue that was raised in the order, and this was a great point by the court, that at trial we did have testimony of both of our witnesses, and to a certain extent much of the actual grazing that occurred on the property did get into the record. And so the court's question, and specifically this was to my client, how were we prejudiced by the ruling in the motion in limine? And I would suggest that we were actually prejudiced in two separate ways, and I think the lower court's prejudice is apparent when we look at, and it's a paragraph in His Honor's order following our trial, that he was acknowledging that he viewed the evidence that needed to be presented as that which existed for a fictional ranch. And so that would be the fictional ranch without the pipeline that our client installed, and then also without we call it adverse land. But he acknowledged I believe the top of the third page, that for each of the 2 years in question, in reality, Crosscane grazed hundreds of cattle on the subject property in the first 4 months of the year, and in less months, and might have had a reasonable expectation of profit. And in reality, the carrying capacity of the land might have exceeded 40 animal units. But he went on to say that because of his interpretation of the motion in limine ruling, that the actual grazing that occurred on the property was not germane. And so, of course, our initial position is that if the ruling in the motion in limine was an error, the only thing that would be germane in the entire classification appeal would be what actually happened on the property. And how we believe we were prejudiced is, yes, it limited the evidence, the ruling in the motion in limine, limited the evidence that we did get into trial.
You got your expert witness report in.
Correct.
And he was allowed to testify. Your expert was. What evidence would you have offered but didn't or couldn't of the property's value, assuming use of the well and the extra land?
And I'll start with our expert, and that is a great point. What our expert actually testified to was only about 25% of his entire analysis. So he began his analysis with comparison to the state land lease that's 2 miles north of the property. And that was used primarily to assist him in determining a carrying capacity for the subject property. So because that state land lease didn't have extensive capital improvements like our property does, our expert thought that was particularly helpful in determining what the carrying capacity of our property would have been without the pipeline and the additional land, which that we don't necessarily really even believe is an issue, but the pipeline certainly. So that was the only opinion that our expert actually got in from his written report.
But just to clarify, I'm
Sure.
sorry. I know you said the ruling affected the actual testimony, topics of testimony, but the report itself was not redacted in any fashion following the ruling on the motion, was it?
That's correct.
The report accurately reflected the opinions of your expert.
It did, but he didn't testify or explain the basis as to those opinions whatsoever. So,
As to profitability, setting aside the carrying capacity, because it seems to me the real issue here may be the profit, whether there's a reasonable basis to expect that the agricultural uses will be profitable. As I read the report, the expert testified that in his opinion it would be profitable if used to graze steers. He did not. I think he testified he didn't look at Mr. Marchant's use of the property, profit and loss, anything. But that's not how the property was being used.
well, and it was, we sort of took a two-pronged approach. So our interpretation of the statutory requirements was, not only do we have a 40 animal unit carrying capacity, but we also have incorporated in that requirement the economically feasible number of units. And then, of course, we also have the separate reasonable expectation of profit. What our expert did is when he looked at the most economically feasible use of the property itself, he concluded that a stocker operation would not necessarily be more or less profitable, but more typical. So
But he didn't support at all Marchant's use of the property.
He did a little bit.
As to profitability.
Correct. In the very end of his testimony, I asked him specifically if he was aware of Mr. Marchant's business plan and building his herd year to year, and whether or not, in his opinion, was that a reasonable business plan, and would he expect a profit? And our expert did, in fact, testify that yes, he would. And it was based upon his conversations with Mr. Marchant that he did, in fact, agree that his actual way of operating the property as a cow-calf operation was profitable, was economically feasible.
This is the very end of his testimony?
Correct.
Okay, we'll look there.
Yes.
The court didn't preclude you from examining the witness, the expert, about that topic, did it?
He did not preclude me, but I think it's clear, and that was going to be the second thing I was going to touch on, that even of all the evidence that was presented at trial, basically nearly 100% of it was ignored.
Well, but our review is de novo.
Correct.
So I think the question on appeal is, what would you have offered that you didn't?
Sure.
So that we can look at it now.
Absolutely. And what we would have offered is a detailed analysis of what our expert concluded to in writing. And then as to our rancher's testimony, what got a little problematic here is the fencing in the pipeline, the cross fencing that's used for the rest rotation program, Yes, I'm sorry, the rest rotation schedule that he uses and the pipeline were actually built together. So because of the motion in limine ruling, much of the evidence about the fencing didn't even get in the record. And that's apparent when you look at our expert's report, because he put all the capital improvements together. So our expert was even prohibited from talking about his conclusions into in the report as to the fencing, because he lumped it together with the pipeline.
But your expert report was prepared long before the ruling on the motion.
Correct.
So
and we did not have an opportunity to go back and revise that report.
Right.
So when we arrived at trial on the morning of trial, and I've mentioned this in my brief, we weren't exactly sure what His Honor was going to allow in and what he was going to exclude. And so once he made the determination that the evidence of the actual grazing on the property, that without the pipeline, just with the natural water and runoff from the property, would be allowed, that is how we shaped testimony from not only our rancher but also our expert in an attempt to comply with His Honor's contemporaneous interpretation of the motion in limine. So what we did not get in from our rancher, and I think you will see that I attempted to go to great lengths to bring out the seasonal or ephemeral grazing that occurred on the property in the first 4 to 6 months of each year, and so 2012, 2013, and 2014. Knowing that in the middle of 2013, that is when he started to use, and it's either April or May, that is when he started to use the fencing in the pipeline. So what's not in the record is the actual grazing use that started in 2013, and then also nearly all of 14, because he testified that it was a bad year for him and he had to rely upon the fencing and the improvements.
Well, how would that have changed our record as it respects the expected profitability of the land? Given that we've got the PINALs, we've got the income tax forms that reflected use of the fence, use of the extra land, use of the water.
Right. And I don't necessarily disagree that the profit and loss statements themselves aren't particularly reliable. And the reason for that is not only did our rancher testify at his deposition, but also at trial, that included information that his father had submitted to the accountant. He didn't exactly know what went into and what did not go into, but what we brought out at trial, and this is what we were relying on for the evidence of actual profits that occurred both in 2012 and in 2013, was his reinvestment into the herd. So from 2012, his calf crop profit, he testified that it was his goal to increase the size of his permanent herd by 20 to 25 animal units annually. And so his calf crop that he took, and there is detailed testimony from our rancher in the record regarding this, he went to a livestock auction and said, I'm selling my calf crop for this year. May I start an account? They said yes. They had an account. We actually introduced the receipts from Pacific Livestock that reflected his account. And so our rancher's testimony regarding the actual profit for 2012 is the reinvestment and increasing his permanent herd size by 20 to 25 animal units. And as I brought out in direct examination, that transaction, which is his actual profit, which reflects all of his expenses, that was actually what occurred with all income and expenses, which wouldn't be reflected on the profit and loss statement.
Oh, maybe it should have been. But that was in 2012.
That was in 2012.
And I've read the testimony as to what happened thereafter, and I have a real hard time following it, what he did.
Okay, let me walk you through it.
I don't need to know when he brought cattle on and when he moved them off, but he never says, my herd was this as of this date and that of that date. He never testified as to any of that.
He does.
Well, where? Or
He
maybe
does.
His colleague can tell us.
Yes, okay. So let's go to page, it is, okay, so as of January 2012, this is on pages 58 and 59, his herd was, he said, I believe, approximately 80 cattle, and he brought in an additional, well, I had 150 total, so it'd be 70 of, or no, I'm sorry, it's 100 of his herd, and then 50 of his friends. And then on pages 82 and 83 of the trial transcript, he testifies that as of January 1 of 2013, his permanent herd size was 120 head of cattle. So that was the testimony that we brought out to substantiate the increase in the size in the herd, and then his discussion regarding his deal with Pacific Livestock and Auction follows that, and that should be, it looks like it should follow almost immediately, like on page, let's see here, 85 or 86, I think. Yes. Oh, no, and I'm sorry. And then he also talks about the size of the herd on pages 72 and 73 for tax year 2012. And then his actual profit for 2013 was the 45 calves that he raised in 2013 that he traded to his friend Dan Hardiston to engage in a restaurant venture, which he now regrets. But they agreed at the time that the value of those 45 calves was $50,000.
That's not what was reflected on the income tax form.
That's correct, because he did not, it may have been that the accountant may not have adequately explained to him that that should be reflected in the Schedule F. But I think it perhaps is clear that the accountant didn't give him, for whatever reason, or his father didn't. I think it's pretty clear that he wasn't exactly sure what went into the Schedule Fs or what came out as the expenses. But in no way are we contending that that negates his actual profit or his reasonable expectation of profit. And what we also had an issue with, even under this fictional ranch standard.
I don't think we're going to be looking at the fictional ranch standard. So,
Okay.
Before you leave, what's your best, what legal authority other than the statute shall we look to define what it means to have a reasonable expectation of
Title
profit?
USA. And I think, in fact...
Title USA says we're not going to decide what the standard is.
I'm sorry?
But our court decision in Title USA says we're not going to decide what the standard is. We're not going to tell you what the statute means.
Well, I think Title USA gives you a lot of guidance.
Okay.
And I would argue that actually our case is quite factually similar. That case involved a more of a unique use of the property. That's what's occurring here. It's a cow-calf operation. It's a little bit different than a traditional stocker operation. But in Title USA, the court held that there was no evidence whatsoever that the farmer there wasn't competent, that he wasn't knowledgeable, that he didn't research the way that he was utilizing the property. We have testimony of all of that here in our record. Our rancher, in my opinion, is competent. He's been ranching in Arizona since the 1980s. He's a third-generation rancher from Wyoming. And yes, his family runs cow-calves. That is what he used to. That is what he is used to. And he testified why he does that in Arizona, and it's because of the inherent risk that's involved in a stocker operation. So if you have a bad year and your only potential profit is the gain on your cattle for that particular winter, as our rancher testified, he would have lost everything. He would have lost the 6 years he'd spent building up his herd. And I would actually argue, in comparison to Title USA, we have more evidence of the reasonableness of the profit here, because we also have although our rancher did not get to testify to his opinion, we have evidence of the expectation of profit from operating the property, not only as our actual rancher operates it, which is the cow-calf operation, but which is a more traditional stocker operation. And that's our rancher's second part of his analysis, where he concludes that there would be a positive net operating income of $40,000 for a typical stocker operation that is reflected, the value is reflected in the property itself. So not only do we have reasonable expectation of profit as to how the property is actually operated, but we also have a reasonable expectation of profit and economic feasibility as to how the property could be operated by a different rancher. And it's our position that if the motion in limine was in error, we need to be given the opportunity to have our expert, even though the report is in the record, and yes, I acknowledge that, and certainly we would like this court to look at it and analyze it, but he did not have the opportunity to substantiate his written conclusions through testimony. So that's one of the most important aspects of why we're requesting a new trial. And the second thing is, and this is important too, even though Judge Whitten acknowledged that he was only looking at the property without the pipeline, in 2012 we didn't have a pipeline. So all of the evidence that we did get into the record regarding our rancher's testimony, plus the carrying capacity and profit analysis of our rancher without the pipeline, that was entirely ignored by His Honor. And I'm sorry, thank you very much. I've used all my time.
Thank you, counsel.
May it please the court, counsel, my name is Roberta Livesay and I represent PINAL County. This appeal is only an appeal from the granting of the county's motion in limine, and the standard of review on the motion in limine is for an abuse of discretion. The county is mindful, and also, like the appellant, grateful for the court's direction in last week's order. So I would also like to focus on the questions that have been posed by the court. But I would like first to put the proper context on those questions. A property tax appeal, it's called an appeal even at the tax court level, is not like any other civil case. A property tax appeal carries with it a presumption of correctness, that is placed in statute by the legislature and repeated by this court in many of its decisions. So when the taxpayer comes to court, their first job is to overcome that presumption of correctness. That's really quite important as we go through the analysis of what's going on here, because even though they didn't appeal the granting of the motion for judgment at the end of their case, that's really where they're going here. And what the tax court did was look at all the evidence that was presented and determine that there was not sufficient competent evidence to overcome the presumption of correctness. Now, going back to the motion in limine, the court's first question was, did SWVP suffer any prejudice from the motion in limine ruling? And the answer really is no. The reason the answer is no is because the motion in limine and the ruling on the motion in limine were very narrowly drawn to only preclude opinion testimony that would flow from the use of the water that was not disclosed. All facts that the plaintiff had were allowed into evidence, every one of them. And as you go through the transcripts, as I appreciate that the court has done, you'll see that even with that motion in limine ruling in place, the tax court still allowed a great deal of opinion testimony, a lot of it over my objections, but the court was very generous in allowing the plaintiff to get into evidence every fact that the plaintiff wanted to offer. And still the court found that there wasn't sufficient competent evidence to overcome that presumption of correctness. So if you look at what happened during trial is the rancher freely testified as to all properly disclosed facts. And the trier of fact was free to draw whatever conclusions could be drawn from those facts. He testified about the water pipeline as a matter of fact, that it was there, that it cost him well over $100,000 through a different company, not through the ranching operation, but through a different company to put in that water pipeline. And he had to admit that because it went through a different company, none of those expenses were included on his tax returns, and none of those expenses were attributed by him to the cattle grazing operation when he was expressing whatever opinions he was expressing about them. And the same thing about the fencing. He testified as to the number of animal units that he actually grazed on the subject property and the BLM and state land under the reality of the conditions on the ground, which were for 2012. There wasn't a water pipeline. They had a loss in 2012. 2013, there was a water pipeline. There were no expenses attributed to that water pipeline, but they still had a loss for 2013. For 2013, they had a small profit. That was the year they had the small profit of about $1,400. And then for 2014, they're back into the loss column again. Judge Johnson, you asked about the number of animal units on the grazing on the property, and there is actually testimony in the record that's very easy to see. It's on page 121 and 122 of the rancher's testimony, so that would be day one, and that was on cross-examination. I asked the rancher, I said, you answered that you had approximately 100 animal units at the end of 2012, correct? Answer, correct. And that you increased to approximately 120 animal units at the end of 2013, correct? Answer, yes, correct. And again stated about 120 animal units through the end of 2014, correct? Correct. So we have 100 animal units for his entire cross-cane operation, and that is also reflected at the same pages. That's for your entire cross-cane operation, correct? For our cattle, yes. And that's over the 12,000 acres. So those numbers of animal units were not all grazing on the subject property at the same time throughout the whole year.
What about his testimony that he gave away 45, effectively sold 45 of them to the friend and to buy the restaurant?
There's no record of that. All we have is his testimony, his verbal testimony that he did that. There is
Evidence.
It is evidence, but he testified in the record that he kept careful records of things that affected his ranching operation. Like he wrote down in his range book every time it rained and how much it rained. If he was going to engage in something like that would directly impact on the profitability of his cattle ranching operation, you would expect to see some recorded evidence, documentary fashion, somewhere. This court has repeatedly told county governments throughout the state and the Department of Revenue as well that in classifying and valuing property for property tax purposes, the assessor has to look at the objective facts of the case. The Supreme Court said that recently again in the Marriott CNL decision that I believe we cited. The assessor must look objectively at what's available on the facts on the ground, though I mean that metaphorically, not here because we're dealing with cattle. In the Hayden Partners case, the court said the same thing. You have to look objectively at it. So the assessor cannot get into the head of every individual cattle rancher that's out there and think, well, are you making a profit or not? You have to show us something. You have to prove it to us. So that testimony is very self-serving. It's testimony, it's evidence, but it's not supported by any other competent evidence that would rise to the level of defeating the presumption of correctness.
Counsel, can I ask you a question about some questions about the reasonable expectation of profit requirement? I know you talked about, you identified whether there was actual profit or loss in any given year. That's a factor. I guess you'd agree that's one factor to look at in trying to determine whether there's a reasonable expectation. Is that fair?
That is correct.
And the fact that there is a loss in 1 year or two, or the tax years in question, it does not resolve the question of whether there's a reasonable expectation, does it?
That certainly would not be the only thing that anyone would look at.
Should we be looking, after the Title USA case, should we be looking at the factors identified in the agricultural property manual?
Though that is certainly a good resource to look at. But I would submit that for this particular case, you don't even have to go to that extent, because we have on the record expenses attributable to this ranching operation that were not calculated in achieving those minimal profits and minimal losses that we know about from the income tax returns. We know that Mr. Marchant worked 40 hours a week and took no salary.
Well, their management fees reflected on the P&Ls, though. Not much, but some.
Right, but if this was something you were looking at objectively, standing outside and looking at it objectively, any ranching operation would expect to have to compensate its ranch manager, and this one wasn't.
No, I wonder whether, the P&Ls show a line entry, an expense paid as management fees. And I'm wondering whether that reflected salary paid to Mr. Marchant.
All we have on the record, Your Honor, is his blanket statement that he took no salary. He said that right, flat out, cold, no explanation. He took no salary. And I believe the tax court referenced that in its minute entry judgment. So just like when you're valuing a shopping center or an apartment building or any other income-producing property, you have to look at it from an objective standpoint. If it's a mom-and-pop operation and there are no management fees, the appraiser has to attribute management fees in order to have an operating statement that's going to make sense to a potential buyer. Now, that's not directly, I can't take line item by line item and make a comparison to a ranching operation, but I can say that the same principle underlies it. You've got to look at all of the aspects that contributed to producing the income from this property and see if they are all accounted for. And here they're not. So we have that $120,000 expenditure of those range improvements that's not attributed. We have the salary that the ranch manager, an objective ranch manager, would be expected to take that's not attributed. So we can look at this and say that there is no reasonable expectation of profit, taking the totality of the evidence that is actually in the record, of the facts that were actually testified to. And from those facts, the judge, as a trier of fact, looked at it all and said, there's not enough here to overcome the presumption of correctness.
I've got a couple of questions. So looking at this record and understanding what the testimony was and what was actually being done over a period of years, would you agree that this probably is not in the category of a hobby farm, as that term's been used in some of our jurisprudence?
Well, I don't really know exactly what the definition of a hobby farm would be. I do know that this particular rancher had lots of other things that he was doing. He had his Marchant Development Company, which is a construction company that he testified about. This was not his sole source of occupation, since it wasn't income involved. It wasn't his sole occupation. He had other things going on. So did he put a lot of effort into it? Yes. What was his motivation? I think I can only direct the court to the record for that.
Well, in the record, is there any testimony or documents that actually detail a business plan that projects over 5 years or 7 years what this rancher intended and expected as a result of these activities?
No, Your Honor, there's not. There's nothing formal that you would expect from a business operation that would allow you to say over a course of time these investments of $120,000 would pay off in this way or that way. It's all very lacking. And if you even look at the questions and answers about how this particular rancher came upon this particular piece of ground and why he started grazing on it, it's all very sketchy. It's all very anecdotal. There's no planning in it except, oh gosh, it looks like this piece of property might produce some browse for the cattle to eat on. But no risk-benefit analysis, no cost-benefit analysis, no projections over a number of years, nothing like that. So all we can look at is what we know about for the 3 years that he testified to.
Then the last question, unless I think of something else. As a matter of law, how much evidence does the taxpayer have to introduce to rebut or have that presumption of correctness disappear, and all of a sudden now you're onto the merits?
I think Mr. Tate gave the court in that case, in the Title USA case, a lot more than we have in this case. So it's, I would say, somewhere between this case and Title USA, or at least up to Title USA, up to and including Title USA.
I mean, some of the law, not necessarily as it relates to taxes, but relates to presumption, is if the proponent introduces any evidence, the legal presumption disappears.
I think in the Eurofresh case, it's pretty well laid out that it has to be competent evidence. And the tax court did focus on that there wasn't, I don't think the court used the word competent exactly. I think that the judge used a different word, but it was clear that that's where he was going with that. And as far as cattle grazing operations are concerned, Your Honor, maybe this goes a little bit to answering your question. There are other parts of the state of Arizona that have bona fide cattle grazing operations on them. I litigated a case, I don't think any of this panel were on it, having to do with almost all of the cattle grazing operations in Yavapai County, for example. And I'm told by some of the experts that I've worked with that Cochise County is an excellent place for cattle grazing. But the experts that I've worked with have told me pretty much across the board that you can tell almost by looking at the land, because it all has to do with how much feed there is, how much water there is, and can the cattle really be sustainable on that ground. We're in an area here where the Department of Revenue is actually briefed by appellant, has come up with a chart that says that this land cannot sustain sufficient number of cattle to meet the legislature's requirement. And that forms your baseline. Then if you want to say that your particular piece of land within this desert area can sustain more cattle than that, then you have a very high burden to overcome. I'm not saying it's impossible, because I do understand that there could be a little tiny spot within a section that could get something more beneficial to the cattle. But you have to have pictures, you have to have records, you have to have profit and loss statements that describe all of your expenses generated that were necessary to generate that income. You can't leave some out and say, oh, I did that with a different company, so I'm not going to include it here. That destroys the competency of all of the other evidence, all of the other testimony that you've provided at trial. But I would like the court to go back to the fact that we are really not engaged in an appeal of the granting of the directed verdict motion. What we're really engaged in is an appeal of the granting of the motion in limine. The directed verdict isn't even raised as an issue in the opening brief. It's 4 issues related to the motion in limine, 2 related to fictitious issues that the tax court ruled on the legality of the water source. Tax court never did that. And then 1 issue related to the award of attorney's fees as a sanction against this particular appellant, because instead of giving the county the water certificates and identifying the water source for this cattle grazing operation, they flooded us with 71 certificates of well registrations that had nothing to do with this cattle grazing operation, but that we had to expend considerable government resources in tracking them down. And while I do litigate water cases, I don't litigate water rights cases. So there's a difference between flowing water cases and water rights cases. We had to engage another attorney to help us sort through this puzzle that they had given to us. And the only piece of the puzzle that was missing was the 1 piece that related directly to this case. So the sanctions that they experienced for the blocking of their opinions had to do with their own bad behavior in the discovery phase of this trial. And that has to influence everything that came after that, even though, as I said, the trial court was actually very generous in allowing them to get all the facts in, and even some of their opinions.
On the fees issue, and I'm glad you raised that before I forget it, the 12-349, I'm sorry, 12-350 says that when a court awards fees under 12-349, the court shall set forth the specific reasons. Here, the record is pretty odd about that. On the one hand, the court says you're not going to award fees, and then ends up signing a judgment that does award fees without setting forth the reasons. Why should we uphold that award?
The court's reasons for awarding the attorney's fees are set forth very specifically in his ruling on the motion in limine. And we did ask for fees after the motion in limine, and I believe the court was simply relating back to the reasons that he set forth in that particular ruling. Now, as far as the two forms of judgment are concerned, I think the first one was just inartfully signed. That's not really a good adverb to use, but maybe an oversight. The fact is that when the court signed the formal judgment, the court awarded the attorney's fees in the exact amount that we had asked for, and then when they had to go back and redo the judgment to get the Rule 54 language in, the court affirmed the awarding of the attorney's fees. So I think the court was always clear on the reasons and on the award of attorney's fees. And they, again, relate back to just the disclosure discovery violations, which were pretty severe in this case. I still have time left, but since the court has no questions, I will let the court have the time. Thank you.
Thank you, counsel. We will take this matter under advisement and issue a ruling in due course, and thank counsel for their briefing and argument here this morning. We'll take a brief recess to allow counsel for the next case to come forward and get set up for our next argument. Thank you.